And I always came in, and the other thing that I recognized, in addition to having to do the campaign work, the other constituency group that I had to satisfy was, as you anticipated, the members of the court. So unfailingly, I was prepared. Without question, I had read everything. Without a doubt, I had written my own fact statements. Oliver Wendell Holmes said, I don't write the opinion, I write the facts. The facts dictate the result. I write the facts, I hand the facts to my law clerks, they come back with the result based on my interpretation of the facts. That's what I did. I wrote up the facts, the law clerks would come back, we would go over the analysis, and I really, 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 like Patty Boyle and Chuck Levin, could take a lot of pride in the fact that most instances, more than 50% of the opinion that got produced was my own. Chuck and Patty were more like 75%. But my direct personal contribution to the work that got published in a very large instance was my own. So the intellectual integrity associated with my work product, the people on the court understood and appreciated. So, you know, I mean, they saw me as a good colleague. They saw me as a responsible colleague. They saw me as a prepared colleague.
And you felt welcomed.
And I felt very welcome, very welcomed.
Yeah.
And I was always a little bit of a disappointment to Chuck Levin because I had shaded to what he called the right with Patty Boyle. But man, think about this. You're two of the smartest lawyers that the world has ever produced. Patty Boyle and Chuck Levin arguing over issues associated with criminal procedure, really trying to knock down drag-outs over Miranda and what did it mean, and if the police knows that a lawyer is in the waiting room, and while the defendant hasn't asked for him, the mother has sent the lawyer there, and the police know the lawyer is there, but they let the kid go on and waive his rights. Patty said, what are you talking about? It was free and clear. He did it on his own. And Chuck said, what are you talking about? The police knew that the lawyer was standing in the hallway. If they had said to the kid, the lawyer that your mother hired is here, now do you want to waive your rights? He just said no. So, I mean, that's actually a closer call than you think. In that instance, I agreed with Chuck, but easily, and Patty wrote a profound opinion, which went the other way. They said it doesn't make any difference. No one tore his fingernails out. No one caused this young man to do anything other than freely waive his rights. Who cares what he knew or didn't know? That's not the standard. The standard was on his own volition, did he waive his rights with no prompting from the police? What are you talking? The police withheld from information. They do that all the time. Cut it out. And I mean, you know, so this is so on the court itself. I mean, so you think about this. It's like a ping pong. We're both doing this. Everybody's moving their head from side to side, waiting for Chuck, waiting for Patty, waiting for Chuck, waiting for Patty. It was always, man. I mean, you know.
What were some of the other big cases that you can remember?
You know, I mean, a huge case, Butson and Nevers. You know, and this one, people ask me.
Starsky and Hutch.
Starsky and Hutch.
Malice Green.
Malice
right?
Green.
That's all that. And tell us a little about that.
Well, you know, Malice Green was the young man who had in his hand a bolus of cocaine. And Officer Nevers and Officer Butson were
Detroit
policemen who believed that if they could open up his hand, they would have evidence associated with the fact that he had committed a felony because he had in his hand but he had enough cocaine in his hand that would have caused him to be at least indicted for possession of a felony amount of cocaine. So in the process of trying to open his hand, he was killed. And so the question is during the course of their trial, for whatever crazy reason, the bailiff goes out they're on break, and he gets the jurors a movie. What's the movie that he gets them? Malcolm X, starring Denzel Washington, produced and directed by Spike Lee. 6 of the members of the court all say that the fact that this was a movie about a very important, but also very radical member of the African American civil rights community could have had the potential to politically inflame the jury. And thus their initial decision to find them guilty of second-degree murder.
This is the jury.
This is the jury.
Yeah.
Was unfairly influenced by the fact that they had watched that movie. And I disagreed, and it was 6-1.
This is on appeal. This is to the Supreme
Court.
Michigan
Supreme Court.
Yeah.
And so it's on appeal. I can't remember. My supposition is very, very likely that the Court of Appeals overturned their conviction. It came to the Supreme Court. We heard it because it was a very important case. And the court, 6-1, in fact, ordered a new trial. My own view was that, frankly, I didn't think the movie was important enough.
Let's make it clear. Nevers and Budson were convicted by the jury in the original trial.
That's right.
And so the Supreme Court's basically overturning this and saying there ought to be a new trial. You were the lone dissenter.
That's right.
Okay.
That's right. And my own view was that, frankly, the movie was not strong enough. And I remember my clerks, because I wrote a really harsh critique of the movie. And my clerk said, Justice Mallett, you can't put that in there. It's not enough of a basis to say you don't want to have a new trial because the movie was terrible.
You were a film reviewer, Monte.
Exactly.
Yeah.
And part of my argument was that this was really a fairly poorly constructed movie that didn't have as much social relevance as Spike Lee thought that it should. And because of its gross deficiencies, both in fact development and personnel development, I didn't think that the jury would have been overwhelmed. I didn't quite say they would have been bored to death, but I didn't think that the court's suggestion that this one movie would cause them to forget 8 weeks of fact presentation made by the prosecutor was valid. The great thing about being on the Michigan Supreme Court, all of my colleagues read my dissent, and every single one of them sent me notes that said, you need to strengthen this, you need to cut that out, you need to make this better. I'm not sure what you mean here. I think this would be better said this way. Every member of the court contributed to my dissent, recognizing that I was going to be by myself. Dorothy particularly said, it's got to be the best opinion you have written, and we're going to make damn sure that it is. And when Dorothy said something, man, on that court, everybody paid attention. And so I think she was the chief, but anyway, she kind of made it the court's assignment. I want you to review Conrad's dissent. I want your best clerks to go over it. I want substantive comments delivered to him by X day. And Conrad, I want you to read them all, and I really, really want to see evidence of the fact that every single one of the suggestions that got made had been clearly and appropriately considered. So it was like, we were like high school students, man, and Dorothy, all 5'1" of her, all 101 pounds of her, were giving out orders that every single one of us followed to the T.
Well, now it sounds like you had a lot of mutual support for one another, or at least you did in that instance,
yes.
Her to you. Is it that way, or was it that way with a lot of other cases, or was this unusual?
I think the Budson and Nevers case was unusual. I do think, though, that, you know, we were a very traditional bunch. You know what I mean? I mean, you know, Bob Griffin had been in the United States Senate, I don't know, 30 years. I mean, he'd been a long-serving member of the court. Jim Brickley came to the court, after having been a lieutenant governor, after having been an FBI agent, after having been the United States Attorney General, Detroit City Council person, just really a former president of Eastern Michigan University, a profoundly a gifted public servant. And so, you know, I remember that there was a workers' compensation case written by Brickley that was decided, Bill, in the 1930s. Something to the effect that if the worker was injured out of state and was re-injured in the state of Michigan, that the length of time for the injury would go back to the original, because it was a statute of limitations case, something along the lines. And Brickley disagreed with that. He said, look, this is the state of Michigan. What happened in Indiana doesn't count here. But then he went on to write, but this has been the state of the law since 1930, and I'm not going to upset it now. And he pointed out that this particular question has been reviewed by this court 10 times. And every time it's been reviewed, they say that the Indiana injury counts toward the Michigan statute of limitations. I think that's wrong, but I'm not going to overturn it. The legislature needs to confront this, recognizing that this misinterpretation exists. And he said, but it's instructive to me that in all this time, the state legislature knows that this is the opinion of the court and hadn't done anything about it.
That's so-called stare decisis, meaning honoring precedent.
Honoring the precedent. And it was a profoundly important moment that we all revere now. And I don't want to get into a fight with the current court, but I will simply say this, that there have been courts since I was, after my exit and after Governor Brickley's exit from the court and after Senator Griffin's exit from the court.
Everybody's gone except Mike Kavanaugh. He's the only one left.
And so there have been courts that have said, no, the decision is wrong, and stare decisis is not necessarily a rule of law. It's more of a legal tradition, and we're not going to go down that road. Very different than what has gone on.
Well, who's right and who's wrong?
I think James Brickley is 100% correct. Going back to the admonition given to me by Griffin, the job of a member of the court, among other things, is to protect the institution. And I think that in that instance, that was exactly what Jim Brickley was doing. And you can
so
make it. You can
all
make
things being equal, there should be deference to past decision making.
It is.
If at all possible.
Certainly my opinion.
Yeah.
Certainly my opinion.
Okay. Well, let me ask you a couple other things. The Supreme Court itself, we have a peculiar way of doing things here in Michigan, you know. We nominate our candidates for the Supreme Court at party conventions, and then they're elected on a nonpartisan ticket in November. Yeah. And of course, if there is a resignation, as in your case, both when you entered the court and when you left, the governor appoints a successor. Do you think that's a good system? It's been widely criticized. A lot of people say we shouldn't be electing our judges at all. Other people say, well, we should elect them, but in a different way. Other people say we should appoint them, and we should appoint them this way or that way or whatever. What do you think?
My own view is that, I mean, the current system, I think, works, and here's why. Bob Young, who's a member of the court now, was first appointed. Brian Zare, who's a member of the court now, was first appointed. Steve Markman, who's a member of the court now, was first appointed. I think whoever takes...
Well, Cliff Taylor was appointed and became Chief Justice, was defeated in 2008.
Right, so whoever takes Hathaway's case is the point. The point that I'm making, Bill, is this. In more than 50% of the cases, the members of the court are first appointed, then run. Very rarely does a member of the court come to the court from a standing start, nominated by the party, run for election, and then get elected. That almost never happens. The thing that's critical in a Michigan Supreme Court race, and you know this, is the designation, justice. 90% of the time, the people who elect you are looking to see whether or not they know you, and they assume by the fact that you're on the ballot with justice in front of your name that you meet the minimum qualifications. 99% of the time, their assumption is correct. You've met the minimum qualifications. The governor, having vetted you, and all of these, and if tradition holds, and I'm sure that it does, these cases, excuse me, these appointments are first gone through. The governor consults with the state bar. State bar says qualified or not. Now, sometimes it's minimal qualifications, like in my case, they wrote down just barely.